Hello, everyone, and welcome to Uncivil Law. I hope you're having a good day. For today's case, we have a decision from the Court of Appeals for the Ninth Circuit. This case is the case of Shana Becerra versus Dr. Pepper / 7-Up. In this case, Shana is suing Dr. Pepper because Dr. Pepper makes a drink called Diet Dr. Pepper, and Shana did not lose weight drinking this. She is suing on the basis that the term diet is misleading because an ordinary consumer hearing that title would understand it as a weight loss product, and therefore she was misled and bought it under false pretenses. So we're going to learn about Shana's complaint against Diet Dr. Pepper and read what happens next. Super exciting! Appellant Shana Becerra sued appellee Dr. Pepper, 7-Up, Dr. Pepper, alleging Dr. Pepper violates various California consumer fraud laws by branding Diet Dr. Pepper using the word diet. After the district court dismissed her third amended complaint with prejudice, Becerra appealed. We affirm. So we have a woman suing because Diet Dr. Pepper did not give her the body that she was craving. What was the basis of her argument? Becerra's second amended complaint alleged that the label diet misled Diet Dr. Pepper consumers by promising that the product would assist in weight loss or at least not cause weight gain. Becerra relies on several studies to allege that aspartame, the artificial sweetener used in Diet Dr. Pepper, is likely to cause weight gain and poses no benefit for weight loss, rendering the promise allegedly inherent in the word diet false and misleading. Dr. Pepper moved to dismiss the second amended complaint, and the district court granted the motion without prejudice, concluding that Becerra failed to sufficiently allege that reasonable consumers would understand diet in soft drink brand name to promise weight loss, and that even if she had, the scientific studies she cited failed to support her allegations that the promise was false. Becerra amended her complaint, and Dr. Pepper again moves to dismiss. After a hearing, the district court granted Dr. Pepper's third motion to dismiss. The district court found that no reasonable consumer would believe the word diet in a soft brand drink's name promises weight loss or healthy weight management. Becerra timely filed an appeal. She is so peeved about this, she's appealing her decision. After 3 bites of the apple, the district court, she had a third amended complaint, and they dismissed it, and she's appealing. Good for her, I guess. Claims sounding in fraud or mistake are subject to the heightened pleading standard of Federal Rule of Civil Procedure 9b, which requires that such claims state with particularity the circumstances constituting the fraud or mistake. That includes the who, what, when, where, how of the misconduct charged. In fraud cases, plaintiffs must set forth what is false or misleading about a statement and why it's false. The allegations of fraud must be specific enough to give defendants notice of particular misconduct which is alleged to constitute the fraud charged. Becerra's claim under the California Consumer Protection Statutes are governed by the reasonable consumer test. Under this standard, Becerra must show that members of the public are likely to be deceived. This requires more than a mere possibility that Dr. Pepper's label might conceivably be misunderstood by some few consumers viewing it in an unreasonable manner. Rather, the light of the consumer standard requires a probability that a significant portion of the general consuming public or of the target consumers acting reasonably in circumstances could be misled. So California law, like most law in this area, is governed by the reasonable man test, a reasonably prudent person. Would a reasonably prudent person be deceived into thinking it's one thing when it's in fact another? That's the relevant test. A person of ordinary intelligence and ordinary caution going through an ordinary course of day, would they be deceived? Not whether the least of us would be deceived, because then no one could have anything nice. So we apply the reasonable man test. A reasonably prudent ordinary person, would they be deceived? That's the question. Becerra's consumer fraud claim centers on 2 primary allegations. First, the word diet in Diet Dr. Pepper's brand name promises the product will assist in weight loss or healthy weight management, and second, the promise is false because aspartame causes weight gain. Because Becerra's claim depends on both allegations being true, she must sufficiently allege both for her claims to survive. We'll affirm the judgment on the basis of Becerra's first allegation and not reach the second. When considering the term in its proper context, no reasonable consumer would assume that Diet Dr. Pepper's use of the term diet promises weight loss or management. In context, the use of the term diet in a soft drink's brand name is understood as a relative claim about the calorie content of that soft drink compared to the same brand's regular option. Diet soft drinks are common in the marketplace, and the prevalent understanding of the term in context is that diet versions of a soft drink has fewer calories than its regular counterpart. Just because some consumers may unreasonably interpret the term differently does not render the use of the term diet in a soda brand name false or deceptive. Becerra also alleges that the use of attractive fit models in the ads implies Diet Dr. Pepper will help its consumers achieve those bodies. You're telling me that using Diet Dr. Pepper will not give me the slim, attractive body of a supermodel? I am hurt. But as the Second Circuit pointed out when considering a nearly identical complaint, the use of physically fit and attractive models using and enjoying advertised products is so ubiquitous that it cannot be reasonably understood to convey any specific meaning at all. Aww. Taken together, the allegations in the complaint fail to sufficiently allege that reasonable consumers read the word diet in a soda drink's brand name to promise weight loss, healthy weight management, or other health benefits. Without this piece of the puzzle, Becerra's consumer claims fail. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.